We have a very important topic today, great speaker, great information. Vice President of Operations, Vince Danzi. Today, we're going to cover an overview of anti-money laundering program requirements, suspicious activity, reporting obligations, and then key concepts about reportable transfers. Without further ado, Vince, go ahead.
Thank you, Drew. Welcome, everybody. Like Drew said, I am Vice President of Operations here at Security Title Guarantee Corporation of Baltimore. And what we decided to do for this presentation is to chop up our FinCEN real estate rule webinar into a two-part series. This way, giving you, the audience, a little bit more detail on some of the background here. And the intent was to try to give you a little bit more of an opportunity to ask questions and maybe go into some more detail on some of these concepts. Just start my presentation here. Just bear with me one moment. I'm using multiple screens, so here we go. So this residential real estate rule that has been put out by FinCEN is actually a very long time in the coming. Really, the rule gets its underlying authority from a statute that was passed many years ago at this point, the Bank Secrecy Act of 1970. This was an act that was really the first of its kind to start limiting the ability of banks to act in total secrecy. And the reason for it was to try to combat what was at the time seen as a rising tide of money laundering crimes relating to converting money that was made illegally and passing it through seemingly legitimate transactions. Some people trace the term for money laundering back to Al Capone's mafia and his buying and operating laundromats. Some people think that the term originated from the imagery of actually laundering money, washing money. But the idea is essentially the same. It's taking money that's illegally obtained and passing it through what are seemingly legitimate transactions and businesses in order to wind up with money that can be used on the open market without fear of prosecution. Over time, money laundering, anti-money laundering regulation and law has been expanded and has evolved to also capture suspicious activities as well. Notably, after 9/11 and the Patriot Act, an increase in emphasis was made to try to not just look for crimes in the conversion of money, but also to try to track transactions that might be legal on their surface, but might be actually being done to further illegal purposes down the road, like terrorist financing. Now, beginning in the late 2010s, it started to be perceived that real estate was a kind of a loophole that criminals were exploiting in order to avoid the regulations that major financial institutions are subject to. Banks, credit unions are both types of entities that have to conduct customer due diligence. They have to implement anti-money laundering programs and suspicious activity reporting, and they have to get to know their customers. And they're actually subject to, the full panoply of anti-money laundering regulation that FinCEN puts out. Real estate settlement providers have always been subject to the Bank Secrecy Act, but they've always been pretty much exempted from the full range of regulation that banks and credit unions and money services business are all subject to. And that was increasingly seen as something that bad actors were exploiting, and using real estate in particular as a way of moving value in ways that might otherwise have been detected if those transactions were being conducted with the involvement of a lender that was regulated under FinCEN's customer due diligence requirements. Then in the mid-2010s, and actually in 2015, the New York Times did an investigative report on the use of shell companies and in the purchases of high-end condominiums. And apparently it had become something of a selling point among some real estate developers that they were marketing condominiums and property overseas to overseas investors. And one of the value adds that they were advertising was that they were able to keep these transactions secret. They wouldn't publish the names of those who had bought the units online. They wouldn't put them in the directory. Sometimes they would even have separate secret entrances into these buildings for illicit actors. And this New York Times investigative report disclosed that some of these purchases were being done by oligarchs in Russia or in other countries that had been designated nationals under FinCEN's OFAC regulations, Office of Foreign Assets Control. And anyway, this investigative report really highlighted that there was this big gaping hole in real estate transactions that was being exploited. And so in 2016, it's hard to believe that we're actually now about 10 years from the date of the first geographic targeting orders were issued. But in 2016, FinCEN issued the first of these geographic targeting orders. And these geographic targeting orders were targeted, first of all, they were targeted at title insurance companies. And by extension, their title insurance agencies that were working on their behalf. But it specifically targeted locations in New York and in Florida, where it was seen that this was an especially problematic and widespread practice. And it was at first implemented with the idea that FinCEN was going to see how productive this was, how many of these transactions that it was going to now require reporting on, how many of those would actually be transactions that they would otherwise be interested in. Over time, they continued to expand these geographic targeting orders to cover properties in Texas, and Nevada, and California, and it was generally felt by FinCEN and by law enforcement that these GTOs were actually disclosing actionable information, and some crimes were actually prevented apparently by the information that was reported through these geographic targeting orders. And what you're really seeing now with this FinCEN real estate rule that happens to be going into effect at the day after the last GTO will actually expire is that FinCEN has now decided that they're going to formalize and make permanent this reporting of these transactions that they've found a higher incidence of illicit activity on. The GTOs were always temporary in nature. They were issued according to FinCEN's authority to issue temporary geographic targeting orders for a maximum of 6 months. And so for the last decade, you've had these daisy-chained geographic targeting orders where one geographic targeting order expires and the next one picks up. That's finally going to be ending at the end of February to be replaced by this real estate. And like Drew said, feel free to jump in with any questions that you may have. Now, this FinCEN real estate rule, it didn't just pop into existence out of nowhere. It was the subject of a prolonged promulgation process. In December of 2021, FinCEN first issued an advance notice of proposed rulemaking, seeking public input on this rule. That was concluded in February, and then in February of 2024, FinCEN issued an actual notice of proposed rulemaking detailing the specific framework of what it would eventually promulgate as this real estate. Again, there was a public comment period that finished up in the spring of 2024, and in the summer, late summer of 2024, FinCEN finally published the real estate rule in the Federal Registry. And that's really the first time that we all got a chance to look at the actual details. In September, after much angst, well, originally this rule was going to go into effect December of 2025, so it would have already been in effect. The problem with that is that FinCEN had not released much guidance on the rule. As of September, there still wasn't an actual form to share or to study off of. So there were a lot of questions about the rule, and it was the effective date was delayed until March 1st of this year, 2026. So the first residential real estate reports will be due actually by the end of February. I'm sorry, by the end of April, because actually I shouldn't say that. Actually, March 31st would be the first effective day. If you had something that closed on March 1st, it would be due on March 31st, because unlike the GTOs, which had a rolling 30-day due date, the due date for the real estate rule is the later of 30 days or the end of the calendar, the end of the month following the month in which the transfer occurs. So that is usually going to give someone at least a month to make this report. But whether the transfer actually occurs on March 1st or February 28th is actually a big deal. Because if the transfer happens on February 28th, this rule will not be in effect yet. If it goes into effect on March 1st, you will actually have to make the report. So what that actually means is that we are going to have to start providing information to our clients much sooner than March 1st. Because if a transfer actually happens on March 1st, we want to actually be in a position to go ahead and make that report. We don't want to be waiting for the rule to go into effect to start our information collection. And we will go into the mechanics of that shortly. So what is the residential real estate rule? Well, simply put, it is a regulation that is found in the Federal Registry. It's authorized by the Bank Secrecy Act. It's implemented by the Financial Crimes Enforcement Network, and it's conceived of as a streamlined form of suspicious activity reporting for financial institutions that are persons involved in real estate closings and settlements. That's us. So it's a special abbreviated form of suspicious activity reporting is one way of looking at it. If you were to put it in a single sentence, I would say the rule is that a reportable transfer, as defined in paragraph B of this section, shall be reported to FinCEN by the reporting person identified in paragraph C of this section. Now that's one sentence, and it's loaded with terms that we then need to understand. The financial institutions are, of course, us as persons that are involved in real estate settlements. We talked briefly about the Bank Secrecy Act and FinCEN. One thing I do want to mention right at the outset is that a lot of great materials are already available now on FinCEN's official website for the rule. They've created a special URL for the rule, which is found at www.fincen.gov/RRE. Okay. Now, before I even get into this reportable transfers, I do think one thing that is important to note, and I think one of the great things about having these seminars is that the feedback that comes from these seminars is extremely helpful in getting everybody prepared. One of the things that I've heard over and over again by different people, it's really a misapprehension, but many attorneys in particular believe that they are not going to be subject to this rule because their clients, their purchasers are United States entities or trusts. Now, that's a misconception, and I think the misconception arises because there's some confusion between what is this residential real estate rule compared to the Corporate Transparency Act and its requirements that beneficial ownership information be reported to FinCEN. We're going to talk about what beneficial owners are in the context of this rule, but what's important to understand is that the residential real estate rule borrows the definition and the concept of beneficial owners from the Corporate Transparency Act, but that's it. The Corporate Transparency Act beneficial ownership information regulation, which was happening pretty much at the same time as this residential real estate rule was finalized. You might remember that the Corporate Transparency Act's rule was pared back quite a bit at the beginning of last year. The Secretary of the Treasury had authority under the Corporate Transparency Act to exempt certain classes of reporting companies from the regulation if the Secretary thought that the regulation was going to be overly burdensome. And that's what Scott Bessent did. He, really at the last minute, issued an interim rule where he said domestic entities would not have to report the beneficial ownership information as part of the Corporate Transparency Act. That's still in effect. That exemption still exists, but it is different from the residential real estate. The Corporate Transparency Act's beneficial ownership information reporting had to do with the existence of a legal entity as of a certain date, whereas this residential real estate rule has to do with deed transfers that take effect after a certain date. Domestic companies are going to all the time be reported under the residential real estate. We know that the Corporate Transparency Act no longer applies to domestic entities, but I would say the vast majority of beneficial ownership information that's going to be reported under the residential real estate rule is going to be from domestic entities. And the residential real estate rule looks at that definition as a convenient way of defining what a beneficial owner is. But it is the exemptions from the two regulations should not be confused, and they are actually often being confused right now. So that's one thing to keep in mind. So when you hear someone say, "Oh, I don't need to worry about that," think again. We all need to worry about this. So what is a reportable transfer? So like many things in this rule, the definition that is first given is very broad, and then you subtract from it. So except as set forth in paragraph B2 of this section, a reportable transfer is a non-finance transfer to a transferee entity or transferee trust of an ownership interest in residential real property. Now that sentence is constructed with almost entirely defined terms here, and I've actually not even bold-faced every one of them, but we will talk about each of these now. A non-finance transfer. This is one of the areas where the residential real estate rule is different fundamentally from the geographic targeting orders. The term non-finance transfer means a transfer that does not involve an extension of credit to all transferees that's secured by the transferred residential real property and extended by a financial institution that has both an obligation to maintain an anti-money laundering program and an obligation to report suspicious transactions under this chapter. In other words, it's the absence of financing by a regulated bank that triggers reporting, and not the involvement of hard money or other specific types of financing. Now, that's a really important concept, and it's another area where there's a lot of confusion, it seems. For those that are familiar with the GTOs, for those that have been in jurisdictions where the GTOs have been in effect, you know that there's always been a threshold, a consideration threshold below which reporting was not necessary to be made. I think that's generally now 300,000 in most of the jurisdictions. I believe it's 50,000 in certain areas of Baltimore. With the residential real estate rule, there is no financial limit, and it actually applies to no consideration transfers. And that's a very, very important distinction, not only because it means that more transactions are going to be subject to it, but it also means a whole different type of transaction or transfer will be subject to it. And right now I'm thinking courtesy recordings. You know, those of us in the title business for any length of time, we know that there are transfers that are for consideration. Those are the ones that we normally insure. And then there's a whole ecosystem of transfers for no consideration. And we are oftentimes asked to record deeds as in connection with transactions that we are insuring. Sometimes we're asked to record deeds out of courtesy. So there could be situations, there likely will be situations where you have transfers that are exempt from reporting and transfers that are not exempt from reporting as part of the same transaction. And one other thing I want to mention while I have the slide up here is that notice the term is non-finance transfer as opposed to a non-finance transaction or something like that. This is a regulation that applies to the actual transfer. And I wouldn't think of it necessarily as a transaction. That's not exactly what it's aiming at. It's actually aiming at the transfer of legal ownership of a real property interest. Doesn't have to be a refinance, doesn't have to be a purchase. It could simply be the recording of a deed.
Hey, Vince, we had a question.
Okay.
So the question was, if we have till the end of the month following the month of the transaction, wouldn't that give us until February 28th to report the March 1st closings?
Yeah, I probably misspoke at first if I said that. So let's say you have a transaction that closes on March 1st. The calendar, the last day to make that report would be at the end of April. So if your transfer occurs in March, okay, you will have until you basically go to the next month, and then you take the last day of the month. The only time that isn't going to be the case, the only time when the month following the month in which the transfer takes place won't be the case, would be the case where you're closing, and let's say you're closing or let's say your transfer is in late January. In that instance, February, since it's the only month that does not have 30 days, you would actually find that if your transfer was, let's say, January 31st, 30 days from January 31st would probably bring you into the first or second day of March. That would be farther than the last day of February. So yes, thank you for that question. Thank you for the ability to correct that. That is correct. So if you're closing, let's say in March, you're going to need to make that report by the end of April. However, you should really have all the information in place by the time of the transfer, right? Because once that transfer is done and you are somewhere and you are the designated person that must make the filing, that filing has to be made. And it won't be an excuse that you haven't collected the information. So it's important to get your ducks in a row well in advance of the actual transfer itself. So what are reportable transfers? And what are they not? Well, a reportable transfer, we know that it's a transfer of an interest in real estate, but it does not include the grant, transfer, or revocation of an easement. It does not include a transfer resulting from the death of an individual, whether pursuant to the terms of the decedent's will or the terms of a trust, operation of law, or by contractual provision. It doesn't involve transfers incident to a divorce or dissolution of marriage or civil union. It does not include a transfer to a bankruptcy estate, or really any transfer that's supervised by a court. And this kind of makes sense, right? The whole point of this reporting in the first place is to enable the government to have an eye on these transactions. So transactions that happen because someone died or because someone went bankrupt or just under the auspices of a court, that's good enough. And the rule does not define that as a reportable transfer. One of the more important exceptions here that we should talk a little bit about is listed here at Romanet 6, which is a transfer for no consideration made by an individual, either alone or with the individual spouse, to a trust of which that individual and individual spouse, or both of them, are the settlors or the grantors. So I'm sure all of us here have worked with clients that are estate planning attorneys, and they use various vehicles as part of the estate plans that they set up for their clients. The rule does give an exemption for some estate planning transfers, but it's limited. In this case, it's limited really to the use of a trust, where the grantor is the settlor, where the grantor of the deed is the settlor of the trust. It doesn't carry over into other types of estate planning vehicles, like limited liability companies or corporations. And that's a kind of an important concept, I think, to keep in mind when we start talking about courtesy recordings, because clients will sometimes ask you to record a deed, right? Let's say that Joe Public is buying a property, and he wants to, after he purchases the property in his own name because maybe financing is more favorable that way, he wants to also have the title agent go ahead and record a deed into his LLC. That transfer into the LLC, which does not involve a AML SAR regulated lender, that would be a reportable transfer. Transfers that are made to a qualified intermediary for the purposes of doing a 1031 exchange, those are also exempt. Those don't need to be reported. Why might that be the case? Well, first of all, these transfers, if you're not familiar with what a 1031 exchange is, for some transfers, it is sometimes necessary for the qualified intermediary, which is essentially an escrow agent. It's sometimes necessary for them to take title to the real property, and then they hold it for a certain amount, and then they transfer it to someone else. That construct is reported to the IRS at some point. So again, it isn't seen that there is a need to capture that type of a transaction. And then lastly, a reportable transaction does not include a transfer for which there is no reporting person. And that is something to consider when we start talking about the reporting person cascade. Because unlike the geographic targeting orders, this filing requirement is not natively the title insurer's responsibility. And so you could actually have situations where there is no reporting person. Even if the transfer was otherwise reportable, you could have situations where there ends up not being a person who would be identified in the reporting cascade, and that reason can become a justification for not reporting.
Since we had two questions come in, if we're able to grab those before you jump into this next slide.
Sure.
The question was, how does this apply to a foreclosure sale with a cash buyer? I'm not sure if you need further clarity. The question came in a minute or two ago. I didn't want to disrupt you.
That is a good question. In jurisdiction, That's an interesting question, and I don't think it's an entirely settled question yet. In a jurisdiction where you have judicial foreclosures, would that be seen as a court supervised transfer? I don't think we have an answer to that yet. I could see arguments being made both ways, but I do not think that's clear. And there are other aspects of this rule that are not yet clear, and that is really one of them. Yeah, I don't think we've had sufficient guidance yet on that issue, and it will ultimately be a local issue, because you would really be looking to the court. You would really be looking to whether or not that sale would be construed as a court supervised transfer. By analogy, I think that it's something that's kind of a related concept to that, and it's another example of where we do need some more guidance on. In certain jurisdictions, like New York, for instance, religious corporations have to have their transactions, have to have the sale of their transactions supervised. It either has to be approved by the Attorney General or by court order. There is question right now about whether or not that approval would qualify as a court supervised transfer. And if it would be, would it also be fair to say that the approval by the Attorney General would be a court supervised transfer? So that's another gray area here. I think we will get some answers to that, but I don't think we have those answers yet. I will say that there is no penalty for making the report. So in general, where there's doubt, my personal preference would be to gather the information and be prepared to make that report. And I would certainly, if it were me, I would err on the side of making that report. If at the end of the day, FinCEN decides it doesn't need the report, that's great, but at least you're not in a position of having not filed a report when it was actually necessary.
Great. We had two other questions, if we're able to take those now.
Please, go ahead.
This first one is, so if parties come to our office and they sign a quitclaim deed or a donation of real estate, that is a reportable transfer. And then the second part, even if we're not preparing a settlement statement, just charging a fee to prepare the instrument, notarize it, and record it.
Okay. So the quitclaim deed, that would be, unless it was unless you were using it to do an explicitly exempt transfer, like the grant of an easement or something like that, yes, that's going to be reportable. I would even go so far as to say that maybe even most of your transactions are going to be in, most of your reportable transfers will be in that form of a quitclaim deed. Now, that's an important thing to just highlight is, since we're talking about the form of instrument being used, I've had some people ask, well, what about a memo of contract? Isn't that an interest in real property? Well, sure, but it's not an interest in real property as the rule reckons it. If you actually go to the rule yourself, you will see that that the interest in real property that is transferred must be in a certain form. It's either in the form of a deed for real property, or in the case of a cooperative apartment, it's in the form of a UCC financing statement. But quitclaim deed certainly would qualify. And I'm sorry, Drew, what was the other question? You read me two of them, and I'm just blanking on the other one.
Sorry, I'm not sure if we're okay to take kind of a halftime question break, because we've had a couple other questions come through. Are you okay with answering a few more questions now, or how would you like to go about that?
Yeah, absolutely. Absolutely. But I think I remember the question. The question was, let's say we're not recording. Let's say we're not recording, but we're preparing the deed. I think that was the question.
Yeah, even if we're not preparing a settlement statement, just charging a fee to prepare the instrument, notarize it, and record it.
Yeah, well, as you'll see, one of our last slides for today will be the reporting person cascade, and you will see that recording is one of the 7 roles listed in the reporting person cascade. So it doesn't have to be insured, doesn't have to be, it doesn't even have to be recorded, actually. You'll see that there are other tasks in this reporting cascade that can trigger the need to make the report, even if you're not actually recording the document. I think the number of times that's actually going to be the case is going to be exceedingly rare, but it could happen. And that'll become clear when we go over that slide.
Next question is, what about 1031 transfers from the qualified intermediary?
Well, the specific exemption is an exemption to the qualified intermediary. The transfer from the qualified intermediary to another to a transferee would be reportable, because it's the exemption only goes in one direction. It's not just a general exemption whenever a qualified intermediary is involved. It's an exemption to the qualified intermediary. That's the only exemption.
Great. The next question is, what about owner financing transactions where title does not transfer until the owner financing debt is paid off? Are those reportable?
So, and that's another good question, and that was actually one of the earlier questions that was posed. Now, I think that the answer to that question really turns on when the actual transfer of the when the transfer of the interest actually happens. So, is that a reportable transfer? It's probably going to be, but when the transfer is due will be the question, and that'll probably be a transaction by transaction question. So when it's time to actually record or prepare that instrument that will actually transfer ownership, that is almost certainly going to be the time when the reporting window starts, right? So as we will see as we proceed through the rule, the time to report is hinged by the effective date, essentially, of that instrument that transfers title. It's also the reason why, for example, someone who's entering into contract of sale, that isn't the date when the reporting window starts. That might, envision the eventual transfer, but it is the date of the transfer that begins that window of time to make the report. If that makes sense.
Thanks. And if any of these questions, if I ask a question that is you're going to touch on it in a later slide, just let me know. The next question is, if a client wants to transfer property to an LLC, LP, or corporation for no consideration, would this be reportable?
Yeah, I mean, again, unless there's some exemption, and I should mention there are not just exemptions for the types of transfers. There are some exemptions that are going to be rarely used, but if the transfer is to like a bank, if the transfer is to an insurance company, an insurance producer, if the entity is by its nature exempt from the rule, then that type of then the transfer will not be reportable. But generally speaking, yes, a transfer, a no consideration transfer into any transferee entity or transferee trust is going to be reportable.
And this similar topic is reporting required in a sheriff's transfer after a foreclosure sale when the court doesn't authorize the deed, but authority is given by statute.
Yeah, I mean, I think this is a question that again is similar to the question about foreclosure, and FinCEN, to my knowledge, has not gotten this deep into it. And for the time being, I would probably err on the side of caution, and I would be preparing to make these reports.
Okay. The next one, is it practical to collect personal social security numbers and personal information from foreclosure trustees?
Well, a foreclosure trustee is not a trustee of a transferee trust, as the rule reckons it. What's going to be the triggering event would be who the transferee entity is. If the transferee is a transferee entity like an LLC, corporation, or a trust, at that point, that's going to generally determine whether or not the transfer is reportable. And in that case, you will then need to get information about the transferor, which in this case would be that bankruptcy trustee. So the answer to that question really, it's really derivative of your transferee. It's not so much a practice you should employ for transferors who are bankruptcy trustees. It's something that you should, it's the type of reporting that will be necessary on a case-by-case basis, depending on who the transferee entity, who the transferee is, not the transferor. So in other words, no, I don't think as a general rule, you would need to be collecting that information. I don't think you, as a general rule, you need to be collecting information about any particular type of transferor, because we're always talking about the transferee as what qualifies the rule, as what qualifies the transfer as reportable.
Okay. We have two more, and then we'll continue the presentation. If we prepare a quit claim deed to cure a title issue, would you be required to report?
I mean, that's a very interesting question. I haven't had that question yet. My background again would be to, err on the side of caution. But in that situation, you're not. I mean, it's tough. I guess it would also depend on maybe what you're correcting. Are you correcting are you correcting a mistake in the legal description, or are you correcting that you didn't get one of the heirs to sign off on a transaction that had already been done? Arguably, you might be conveying an interest in real property under one of those scenarios, but not in another. But generally, if what I'm doing is confirming or adding an interest that had not previously been conveyed, I would be inclined to say that's a reportable transfer. But that's a very good question. And I mean, and let me just say, my instinct tells me that's not. I don't think that is the type of transaction that FinCEN was really aiming for. But unfortunately, I think this rule, and like all rules, I guess, have this same weakness. But this rule is going to impact things that FinCEN really didn't intend to impact, and that might be a good example of one. And I'll see what more information I can get on that. That's a very good question, and it would be great if we got some guidance on that.
Okay. The last question before we continue is, if the rule is defined as non-finance transfer to a transferee entity or transferee trust, would we only be responsible for reporting transfers going to an entity and not from an entity?
So yes, so like I was mentioning earlier, the identity of the transferor is essentially irrelevant. It is the transferee which determines whether the transfer is reportable or not. If the transferor is a natural person, you're reporting things like their name, their address, their date of birth, things like that. If it's a business entity, you're reporting the name and their address. If it's a trust, you're reporting the name of the trust, the date of the trust agreement, you're reporting who the trustees are, but you're not going deeper than that. So, you know, by breaking this up into two parts, I guess I'm kind of having to jump between the two different parts here, but the information that is required of transferors is much more abbreviated than that which is required for transferees. I started off this this presentation talking about beneficial ownership information. That's really only important when we're talking about the transferee. Whenever you have a reportable transfer, the transferor, you're only reporting very basic surface information about the transferor. The real detail comes from the transferee. So the answer to that question is who your transferor is completely irrelevant. It's their identity is something you'll need to report, but it's all about the transferee.
Great. Well, then, those are all the questions for now.
Okay, good.
Take more later.
So the next concept to become familiar with, and this is a really simple one, residential real property. If the transfer does not involve residential real property, it's not a reportable transfer. Residential real property is real property located in the United States that includes a structure that's designed principally by occupancy by 1 to 4 families. It includes land in which the transferee intends to build that type of structure. It includes a unit, like a condominium unit, designed for that occupancy, and it includes a cooperative apartment unit. So that's pretty much straightforward. I think generally you'll know pretty clearly whether or not you're dealing with real property or not. You'll either have a house on it, or it will be zoned in a certain way. But I doubt that there will be much controversy about whether property fits the definition of residential real property. One thing, though, to keep in mind is that where you have mixed properties, right? Like you have a property where you maybe have a storefront on the ground level, on the street level, and then you have 3 or 4 condominium units above it. The transfer of those condominium units, each one of those condominium units, those would be reportable. But maybe the transfer of the entire property, the underlying property, the commercial property in particular, that would not be reportable. So we were talking about transferee entities, and I started off by explaining that the rule starts off with a very broad definitions and then pairs those back. And transferee entity is a great example of that. A transferee entity is any transferee other than a transferee trust or an individual, like a natural person, and it specifically includes the following types. It excludes security reporting issuers, it excludes governmental authorities, banks, credit unions, money services businesses, brokers or dealers in securities, security exchange. It excludes insurance companies. It excludes state licensed insurance producers, like many of the people on this call today. It excludes Commodity Exchange Act registered entities, public utilities, financial market utilities, and any entities that are owned directly or indirectly by one of these exempt entities. Okay, Transferee Trust, again, Transferee Trust has a pretty broad definition. It means any legal arrangement created when a person, generally known as the grantor or settlor, places assets under the control of a trustee for the benefit of one or more persons, each generally known as beneficiary or for a specified purpose, as well as any legal arrangement similar in structure or function to the above, whether formed under the laws of the United States or a foreign jurisdiction. A trust is deemed to be the transferee trust regardless of whether residential real property is titled in the name of the trust or in the name of the trustee in his capacity as trustee of the trust. Like the transferee entities, trusts that are securities reporting issuers or where the trustee of the trust is a securities reporting issuer would be exempt. Any entity that is owned by those exempt transferee entities, any transferee trust that's owned by those transferee entities that are exempt would also be exempt. And you notice here, a transferee trust also does not include a statutory trust. Now, that's an important thing to understand because a statutory trust, a transfer to a statutory trust, is actually a reportable transfer, but it's treated as a transfer to a transferee entity. For those of you who do not practice in jurisdictions where there are statutory trusts, a statutory trust is really much more similar to like a limited liability company or a corporation than it is to a trust. A transferee trust is an express trust. It's a trust that's really an arrangement. It's a relationship. That's what a transferee trust is. A statutory trust actually exists separately from its owners. It's actually its own separate thing. Just like the way a corporation exists separately from its owners and a limited liability company exists separately from its owners, a statutory trust is a similar type of concept. And for example, like a Delaware statutory trust, which are often used in conjunction with like 1031 exchanges. That's a good example of a entity that would be reportable, but it just wouldn't be construed as a trust. It would be construed as an entity. Now the reporting person, this is where it gets kind of interesting. The default reporting person is determined according to a cascade of roles that's set out in the residential real estate rule itself. The default reporting person may enter into an agreement with another person that's also in the cascade, and if they do that, and they do it in the way that the rule specifies, then the responsibility for making that filing will be transferred to the person that it's delegated to. Now, it's important, though, to remember that that transfer of authority, that transfer of responsibility, rather, only happens when the transfer, when the designation is made within the reporting person cascade. So if let me go on to the next slide and it'll actually become clear. This is the reporting person cascade. So we talked earlier about the fact that the geographic targeting orders were innately targeted to title insurance companies and their agents. That is not the case with this residential real estate. The person primarily that would be responsible for reporting under this rule will be the closing or settlement agent that is listed as such on the closing or settlement statement for the transfer. If there's no person that's named that on the settlement statement, then the next responsible person would be the person that prepares that closing or settlement statement. I think we all know that practically speaking, those are going to almost always be the same person. But if there is no such person, well, then it's the person that files the deed with the recordation office. Now, if there's no such person, and this is kind of weird, gets a little fuzzy, then it would be the person that underwrites an owner's title insurance policy for the transferee with respect to the transferred residential real property. Now, you might ask, when are you ever going to have a situation where you're issuing an owner's policy, but you're not recording the instrument? I really don't know. That's a question better posed to FinCEN. I haven't gotten a good answer to that, but suffice it to say that title agents are generally going to find themselves either at position 3 or 4. I guess where you might see that distinction play out is in the issue of a courtesy recording, right? Because In that situation, you might be recording one instrument that you're insuring, and that you also coincidentally happen to be underwriting an owner's title insurance policy with. But for that courtesy recording, not necessarily are you underwriting a policy for that. In that case, you might simply just be recording it. If there's no one at position 3 or 4, then the next most likely person that would be responsible would be the person that disperses in any form the greatest amount of funds in connection with the real property transfer. And if there's no such person there, and again, we're getting into really, unusual situations, then it would be the person that provides an evaluation of the status of title. And if there's no such person at any of those roles, then it would be the person who prepares the deed. And if there's no such person involved in the transaction, then a report will not be required. Now, a couple things to note about the reporting person cascade is that the person who can make the designation is the person that's determined by this reporting person cascade. And that innately means it's the topmost person, right? Because the reporting person cascade isn't just a list of people that are allowed to file the report. It's actually a sequential list in order of priority of who has the actual responsibility for making that designation. So, could you have a person at position 6, the person that provides an evaluation of title? Could that person enter into a designation agreement with someone else in the cascade? It's possible, but the only person that person who's providing an evaluation of the title, the only person they could actually designate would be someone below them on the cascade. It would be the person that prepares the deed. It also means that person can't designate someone above them in the cascade, right? And that should be somewhat obvious, right? Because they're not the ones that have the innate responsibility for making the filing. So what business would they have making the designation in the first place? And that in turn should clue us into the fact that sometimes what we will need is not so much a designation agreement. What we will actually need to do is we're going to need to make inquiry to the parties to understand who actually would show up on this cascade. Is there a settlement agent or closing agent? Is there even a settlement statement? If it's a no consideration transfer, there might not be anyone there. Is someone recording is someone else recording the deed? Is someone else issuing the title policy? So part of our due diligence and in determining whether or not we're going to need to make a filing will be asking some basic questions about who's doing what. And one of the pieces of guidance we are looking forward to providing to you all, our agents, is a questionnaire that you can then provide to our clients that will help everyone determine whose responsibility is it to make this filing. And once you know that, then you know whether or not you need a designation agreement or not. If you're the title agent, you don't want to act like you're always going to be making this report, because you very well might not be making the report. There might actually be a settlement agent. If you're dealing with a hard money lender, you could very well be in a situation where someone else is making that report. And that person might want you to make the report for them, in which case that you would then need to have a designation agreement. We're going to be talking more about designation agreements in our next seminar, and we'll talk about what items actually need to be included on that agreement. But I will leave the discussion about the reporting person cascade with one final thought, which is, if you go to that residential real estate rule website that I mentioned earlier, you will see that FinCEN mentions the possibility of delegating to people that are not in the cascade the function of doing the report. And there's nothing apparently wrong with doing that. Just understand that if you do that, it's not going to relieve you of your responsibility to make the report. So if you go to, acmerealestatereports.com and you use them as your reporter, that's fine. But you, as the title agent, if you're the one that's responsible for making that report, you're going to stay liable. It's different from the situation where you have a settlement agent designating the title agent as the reporting person, using a designation agreement. In that situation, the settlement agent actually becomes relieved of the responsibility of making the filing. So Drew, I think that's our 1 hour mark. I'm happy to take some more questions.
Yeah.
I think that's the last slide.
We have a couple more. There's 3 questions that have come in since the last break. Are you happy to answer them now, or what should we do about respecting the hour?
Sure. No, let's go for it.
Okay. So if you do a sale of residential property by auction, will you have to make a report on a buyer entity?
Is this, I'm not sure if this question is coming from the perspective of the agent is maybe conducting the auction, or somehow the responsibility for making the report is going to be determined according to this cascade. I'm sure in some jurisdictions you have someone who's handling all these different pieces. But what I would say is look at the cascade, determine whether you're actually doing any of these things. And depending on who is doing the topmost of these roles, that's going to determine who has to make the report. But certainly an auction where where the winning bidder was, let's say, XYZ LLC, unless it's a publicly traded company, it's a governmental entity, it's somehow some exempt type of transferee entity, I see no reason why that wouldn't be a reportable transfer, just by virtue of it being an auction.
Next question is, what if I am purchasing a piece of vacant land that will be eventually merged with a residential property? Do I report?
So, again, you're in a situation where you're kind of forced to read tea leaves about what FinCEN meant by intends to build, residential dwelling units. And I think you got to kind of use caution there. And my druthers would be to make that report. I would really always rather be in the position of having made the report and not having needed to make the report than after the fact for FinCEN to come to me and say, hey, why didn't you make this report? You should have. FinCEN, I think, does recognize that there are going to be situations where people are genuinely not sure whether they need to make the report. And if you go to the website and you start poking around, you'll notice that there's 3 different possibilities when you make the report. You can be either making an original report, you could be making an amended report, or you could be making a report that FinCEN has retroactively ordered you to make. So I think FinCEN recognizes that there are going to be transfers that no report has been made, and they're going to have to, after the fact, tell people, hey, we meant for you to be making this report. Go ahead and make that report. Problem with that is it's kind of like fixing the barn door after the horses have escaped, is that, by that time, you might not be in a position to get the information that you need to make the report. So until we get more clarity on those types of issues, I would be preparing to make that report if I had any doubts.
Next question. This might be for next month's webinar, but how do we actually do the reporting? Is it straight through the FinCEN website, or where?
So if you have ever done the geographic targeting order reporting, I think you'll find that the actual mechanics are very similar to it. If you go to the website, you'll see that there's a PDF document. You can download, and you can you have to use a certain browser. You have to actually use, I think, Adobe Acrobat 8, version 8 or whatever it is. But it's a smart form, and you fill out the form in PDF, and then you submit it electronically through the FinCEN website. FinCEN has also said that they are working on and working with software providers to possibly enable batch recording, batch submissions, where multiple submissions are made at the same time. But for us, in the beginning stages of this, I think most of us are going to be filling out individual PDF forms and submitting them on a case-by-case basis.
Okay. What if the buyer does not give you the information?
Well, and really, when we're talking about buyers, we're really talking more than just buyers, right? We're talking about transferees. So someone could very well not be buying it; they're just getting it. Some entity could be just getting it. But the question remains the same: if you have an intransigent, transferee that won't provide the information, you simply won't be able to comply with the rule, and you really just shouldn't be undertaking to do the transfer. If you find yourself on the reporting person cascade, you need to make the report. So if the transferee says, no, I won't give it to you, well, I mean, they have to. They have to, or you can't really do it for them.
The question just came through. I was typing a response up, but as far as getting a copy of these slides and where can we get the materials, is the email that had the PDFs that you sent me, everything that people would need to find through the FinCEN website, and then you're okay with the PDF version of your presentation going out?
Absolutely, and I'm happy to talk to any of the attendees today, either by phone or via email. Work through any of your questions. This is new to all of us, and we're trying to do our best to give as much guidance as we can in the few weeks, several weeks that we have left until this goes into effect. So absolutely, feel free to send that PDF of the presentation, and certainly invite anybody to contact us with questions.
Sure. A quick note, I know we're past 2 o'clock here, and there's a couple more questions, but before any more people jump off, I will have a recording of this webinar here on our website, and it'll be posted on our YouTube page with timestamps so that people can jump around. Just wanted to make that clear. But then the next question is, would the buyer and/or seller attorney always be the first person in Cascade because they prepare closing statements?
Well, will they always be the first person in Cascade? No. I mean, we're there because there won't always be someone in that position, right? What worries me most about the rule are these courtesy recordings, because that's really where I see that we will have questions. But yes, at the top of the reporting person cascade is always that settlement agent or the person that's listed there. However, sometimes it might not be apparent that there is a settlement statement. Now, the definition of a settlement statement is specific. It's actually the list of essentially disbursements made for the transfer for the transferee. Where you don't have an actual formal settlement statement like a closing disclosure or a HUD-1 that we used to talk about, there could be situations where you could even have possibly emails that are exchanged back and forth, and perhaps in certain situations that could be construed as the closing or settlement statement. If you have gray areas like that, I would invite you to contact our underwriting counsel so that we can help you look at that situation on a case-by-case basis. But for the most part, if you're lucky enough to know that you have a closing or settlement statement, I think this is going to be pretty obvious whether or not a title agent finds itself in the reporting person cascade. We're almost always going to be found at position 3.
Okay. This question about possible third-party services to help with reporting. Has there been any official word coming down in the industry, or I'm not sure if you have any answers to that?
If you know what, that question, there's a couple different ways that question comes to us. Some people have asked, is it okay to use these outside service providers to do the filing? That question, I think, has pretty well been answered, that it should be fine to use third-party service providers to do the filing. But like I said earlier, if you end up delegating someone who's not in the cascade, just understand that you're not going to be off the hook for making it. Another context in which that question is asked is, well, what about fees? Can you charge for this fee? And can you pass on the charge of these other companies? And again, this is something that will, I think, ultimately be a local issue. FinCEN has apparently no problem with the reporting persons charging for this service. That's all well and good. It doesn't always answer our questions, right? We don't yet. We to my knowledge, and I actually just was looking this up this morning. I was looking for state insurance departments that have actually come out and given some guidance about this, right? We all know that in some jurisdictions, title insurance is seen as an all-inclusive type of service, that it's actually kind of, even the settlement agent's work is kind of rolled into the premium. And in other states, that's not the case at all. So in certain states, this is going to be pretty much a no-brainer. You're gonna not have any problem at all with charging for this. In other states, it would certainly be good to get some guidance to that effect. What I am seeing generally is that people in general, and I'm just talking nationally, I'm not talking about any particular jurisdiction specifically, but in general, I think most people are seeing that this is a service that is probably going to fetch a separate charge. And I've heard any $200 to $500, even $700 in certain instances that people are thinking that this might cost, or at least be an appropriate fee.
Great. Should title be raising a new FinCEN exception, and if so, will security be providing one?
Yes and yes. So many of us who operate in jurisdictions where there are geographic targeting orders, we already have a Schedule B1 requirement, which puts everyone on notice. Hey, if this is going to go into an LLC and it's for over this amount of money, we're going to need to make this report. Go ahead and please fill out this questionnaire. We are going to be promulgating an alternative to that, which will say, hey, if this transfer occurs on March 1st or thereafter, we might need to make a report. One of the things we're going to provide, so what we're going to do is we're going to include a Schedule B1 requirement, putting the potential insured on notice of what might be required. Like I said earlier, we have come up with a questionnaire that's designed to elicit the information that we need to make a determination about whether or not we, and when I say we, I mean you, I mean the title agent, whether we need to make that filing, or if someone else is going to be making that filing, or someone else will be primarily responsible for making that filing. And then if we determine by that questionnaire that we need to make the filing, then our thought is that we're going to then provide them with information collection forms so that the parties can provide that information to us so that we can then make the filing within that filing window. So yes, we should definitely be implementing a notice procedure to the insureds and providing them some guidance on how we will need to comply with it if the transfer occurs after the implementation of the rule.
Great. Henrietta, about the form for the report and where it can be found. Vince sent me a group of documents that should contain that. Thanks for hanging out for an extra 15 minutes. The video recording will be posted as soon as I get that edited together. This was part 1. Part 2 will be February 19th, Thursday, February 19th, same time. So look out for an email announcement about that. And Vince, do you have anything else that we didn't cover? We covered a lot.
No, I think that's about it. I find these seminars good, especially when we can let the questions kind of steer what we're talking about. So this has been very helpful to me as well.
Sure. Great. Well, thank you, everyone. See, I'm sure most of you in 4 weeks. Hope you all have a great rest of your week. Talk soon.